The simple answer would be no, but then, in typical lawyer-like fashion, I'll turn around and say maybe. So the corporation itself doesn't go into the trust. The ownership is represented by shares in a corporation. In a limited liability company, an LLC, the ownership is signified by ownership interests. So those pieces of paper or those documents, whatever you have as evidence of ownership of the corporation or of an LLC, they can go into a trust. That's absolutely a reasonable thing to do. So the trust has a Schedule A attached to it as that's the list of assets. That's like the climax part of the ultimate end result of your work's efforts. That's the Schedule A. Well, if the corporation is a valuable part of your assets, then you want to put the ownership interests of the corporation into the trust if you're sure that the corporation or the LLC has enough assets to handle all of its liabilities. There's an extensive answer to that question, and that is if you don't have adequate capitalization in the corporation or in the limited liability company, then if a person sues and goes to court, they may indeed grant access to more assets. The court may grant access to more assets. This is why a lawyer and the client talk this over in minute detail to try to understand, is the answer to the question you asked, is it wise to put the shares into a corporation? Short answer is, if it's adequately capitalized, either an LLC or a corporation, and if you are keeping with the corporate form or the LLC form and not, let's say, grabbing money on a Friday afternoon out of the corporate till and going to Tahoe with it, they call that abuse of the corporate form. If you're not doing that kind of stuff, then yeah, the shares should go into, and if you have adequate insurance, then the shares should go into the trust as representing the ownership of the corporation or the LLC.